Good morning to all of you. Honorable 2nd MM Ungol, she has given a circular to all the advocates to furnish the enclosures in the cases of Domestic Violence Act regarding the property, either the complainant or the so-called plaintiff or defendant. So as envisaged or as decided in the famous case law, Rajnesh versus Neha 2020. So in this connection, let us know the case and its actually aftermath or the after effects of the case. So on 4/11/2020, two judges bench, yes, Madam Indu Malhotra and Subhash Reddy, while disposing the case of Rajnesh versus Neha 2020, they have laid down certain comprehensive guidelines to govern the payment of maintenance in matrimonial cases. Right? You may be knowing. So this maintenance is being paid under section 125 crpc, under Hindu Marriage Act, under Hindu Adoptions and Maintenance Act, under Muslim Personal Law and Special Marriage Act. So many acts are there. And so many courts, they are thinking that they are independent of each other. Suppose if a person is asked to pay maintenance under section 125 crpc, when a domestic violence act case is filed against him, that family court is saying that you have to pay this much of amount as maintenance. So there is a clash between things. Some of the high court, they say that each act is separate, so they have to pay both these maintenances. Some courts say no, it's not correct. He can be maybe it amounts to double jeopardy like that. So there is a confusion. Therefore, in order to clarify this confusion, the Supreme Court has given the guidelines. Now let's note the case. This Rajnesh versus Neha. So Rajnesh and Neha, they were married in the year 2012, and of course they were blessed with a child also. But differences, theirs is not a long-lived happy married life, but it was discarded. So the appellant, that is Mr. Rajnesh, left his wife Neha and also minor son in January 2013. Particularly very shortly after the birth of the child. So she waited for 8 months. On 2/9/2013, the wife Neha, she filed a maintenance petition under section 125 crpc in the family court. Of course, the matter was decided after 2 years. The family court on 24/8/2015, they have ordered maintenance of rupees 15,000 to Neha and rupees 5,000 to the minor child. Of course, it was later enhanced also. In the meanwhile, Mr. Rajnesh, he has gone appeal in the High Court, but to no use. Ultimately, now the matter has come to the Supreme Court. Of course, Supreme Court asked him to clear the backlog because around 1 crore or so backlog is there. Right? So actually, here Rajnesh was ordered to pay maintenance to his wife and minor child, and ultimately at this point of time the Supreme Court found the need to frame guidelines, because the guidelines will cover the overlapping jurisdiction under different enactments. Overlapping jurisdiction under different enactments, because compensation can be given in Hindu Marriage Act, Adoptions and Maintenance Act, 2020 crpc, and specific marriage, that is a Special Marriage Act, things like that. So an overlapping jurisdiction and different enactments for the payment of maintenance. So 3 points. Date from which the maintenance has to be granted, has to be given. Number 2, enforcement of the orders of the maintenance. So, and also other things, it can be, in which cases it can be asked. So normally we all know that maintenance can be asked under Special Marriage Act 1954, CRPC 125, Domestic Violence Act 2005, then Hindu Marriage Act 1955, Hindu Adoptions and Maintenance Act 1956. So many things. All these lead to multiplicity of the proceedings, definitely, and they will be giving the conflicting orders. Some people will say 5,000, some people will say 10,000, some people will say 8,000. Right. In this connection, some high courts believed that these laws are independent and maintenance should be paid for each act. So, tadichi maut avutundi vadiki. Right, anyway. In this connection, the Supreme Court said that it would be inequitable to direct the husband to pay maintenance under Special Marriage Act, under 125, under Hindu Marriage Act, and under Domestic Violence Act. So definitely, so the maintenance can be, so it should be clubbed together. So to pay maintenance under each head, independent of relief granted in a previous proceeding, definitely it is unequitable. That's why I told you. So while giving the judgment, while delivering the judgment, the three aspects like justice, equity, and good conscience, they have to be followed by the judge. Now Supreme Court has framed an affidavit. Supreme Court drafted the guidelines that an affidavit should be filed by the parties, by both the plaintiff and also the defendant, to disclose or disclosing their financial status. Supreme Court said that even though there is no straight jacket formula to calculate the quantum of maintenance, normally the court may consider, number one, status of the parties. That's why I tell you, suppose if a rickshaw puller is found to have to maintain his wife, he can be given 500 rupees per month. He cannot be asked to pay 15,000 to his wife. So that is the status of the parties. Second point, needs of the applicant. Yes, definitely. Some people need some medical treatment. Some people need some education, like that. So needs of the applicant also should be taken into consideration. Then income and property of the plaintiff or the respondent. Income, because the social status they will have by the income they derive. Suppose if a film actor is divorcing, he has to pay some crores of rupees or monthly 50,000 to his wife because of the income and property of the respondent. Then fourth, liabilities and financial responsibilities of the claimant. So financial responsibility, they may be indebted to so many persons, they might have taken loan from the banks. These liabilities also have to be taken important. Then a residential arrangement. Sometimes money is not important. The woman has to stay in some accommodation. She has to be adjusted in a rental house. For that, they have to pay the rent. And then maintenance of the minor children. This is another important topic because it is not that easy for people to bring up the children, that to minor children. Then illness or disability, this is another problem. So people, they may have an old man suffering from corona, an old man suffering from paralysis, so many diseases, heart problems, so many things will be there. So, and as regards maintenance, from which date has to be given, the court has clearly stated that maintenance has to be given from the date of filing the application itself. So how it will be enforced? It will be enforced like a decree of a civil court, or if he does not pay, he will be detained, civil detention. And third point, if he pays something and if he does not pay, contempt proceedings also, because he will promise to the court that he will pay the amount on so and so date. If he fails, contempt action also can be taken. Right? So for this purpose, the affidavit will be there. There are 4 enclosures. All these things have to fill. Your financial status should be clearly told to the court, so that they will take a decision. So this is an important case, celebrated case. Tomorrow or when you become advocates, you have to definitely rely on this case. So please remember Rajnesh versus Neha 2020, where clear-cut guidelines are given by the Supreme Court that you have to file the affidavits regarding your financial condition. Thank you very much.